So what am I going to cover? Well, I'm going to just think about sort of parking and why it's important. I'm going to be thinking just so that we can stop and step back and think about the key different methods of granting a right to park or dealing with parking, perhaps in a more generic sense. There was a Scottish case called Moncrief, which I will mention. Kettle and Others and Bloomfold in 2012 had some important stuff to say on parking. There's obviously more case law involved, as is often often the case, haha. But there are a couple of cases in particular that I think Kettle in particular that sort of gives an indication of what happens if things go wrong. I want us to think about protecting our clients' interest, as I say, whether we are drafting documentation dealing with car parking rights, or, as I say, the flip side is acting for the buyer, acquiring land that hopefully enjoys some sort of right to park. And I'm just going to take you through some of the sort of key drafting points and things to think about in some of the documents that you might be involved with. Can a right to park be an easement? Well, yes, it can. Remember, an easement is a legal interest in land, protected by registration. The courts haven't been consistent in their view. A right to park will not necessarily be an easement. Unsurprisingly, each case turns on its own facts here. But the exclusive use of a single available parking space, which is perhaps only just big enough to get a car in, on a small plot of land, probably isn't going to constitute an easement. And then, of course, we then have to turn our minds to, well, if it's not a right to park, what else is it? But that leads us to a different question, really. And the reason for that, really, is that an easement generally still allows the owner of the land over which the right is exercised to still use that land in some way. So an easement isn't necessarily going to confer exclusive, the benefit of exclusive possession.